I'd like to reserve 7 minutes. I think my argument will be short.
How many minutes?
7?
No, 5 is the maximum.
Oh, 5 will be fine.
5 minutes will be great.
I'll just cut it short.
Thank you, sir.
This is a case involving construction that was performed in Sumner County. We filed an action previously. That action got removed to the district court where it was dismissed. And there's an order that we have submitted that dismissed all causes of action, basically, other than one cause of action, which was what we had pled in this case. So we came back to Sumner County again and filed the cause of action on unjust enrichment, and were then presented with a motion to dismiss, which Judge Oliver granted, saying that we had not, in essence, sued or done everything we had to do to recover on a contract basis. We can't. We were barred from all other claims and causes of action other than unjust enrichment as a result of what the district court did.
But there's no question here that your client had a written contract.
At one point with some of the people, but not all of the people, is my understanding.
And that was with Horizon?
I think so. I think from memory, yes. But that cause of action was dismissed. Anything, the way that we've looked at the order from the district court, the only thing that was not dismissed was unjust enrichment.
Well, I mean, the principle, though, that you can't pursue an unjust enrichment claim when there is a written contract is founded on the notion that you can only pursue unjust enrichment in an alternative scenario in that situation. There's not an invalidity here, or the contract wasn't unenforceable, correct? You're just saying claims preclusion, right?
No, I mean, the contract was denied. The contract was deemed unenforceable, in my opinion.
Oh, it was deemed unenforceable.
We were denied.
Do we have a judgment that says that?
We were denied the ability to go forward with it. I don't know if you want to call it denied or whatever you want to call it. We sued on the contract case. It was dismissed by Judge Richardson in the federal court, and it was approved by the Sixth Circuit on appeal.
What basis was it dismissed on?
Various bases, but basically they just didn't feel that it stated a cause, is what I understood. The contract itself was dismissed. Every cause of action that we had, including the assertion of liens, were dismissed. The only carve-out that there was with regards to the unjust enrichment. So that's why we came back and sued under unjust enrichment. And that's kind of where we come down to, in my estimation, what can we sue under? Because we do not have the ability to sue under contract. That was taken from us, was affirmed by the Sixth Circuit, and then we couldn't bring a cause of action based on that. So the only cause of action that we have, the only cause of action, is unjust enrichment. We failed on the contract action, absolutely positively failed on the contract action. So what we're presented with is this one cause of action that we've presented. And respectfully, the complaint, and again, it's a Rule 12 dismissal, the complaint sets forth a cause of action under the recognized cause of action in the state of Tennessee. So the question becomes, you want us to assert some contract action? I can't. I'm barred as a matter of law from doing that.
Let me ask you, is the decision of the federal district court in our record?
Yes.
And in reviewing that, we will find that they dismissed the contract claim. Is that your claim?
What they did is they dismissed all claims that were presented in the case except for unjust enrichment.
Well, if that's the case, in the appeal to the Sixth Circuit, what was the issue on appeal?
We felt it was an error. We felt that there was a cause of action asserted because, again, it was dismissed on a Rule 12, basically.
Well, in reading that opinion, though, it says that the issue on appeal is a dismissal
Right.
of the unjust enrichment claim.
Well, there were other claims presented also. There's a contract claim presented, there's a claim to enforce a lien that was presented, there was the unjust enrichment that was presented. Every claim was dismissed, everything was affirmed except for unjust enrichment.
It's my understanding that the federal court ruled that Kalos could not maintain a quantum merit claim unless and until it exhausted its remedies in contract. Thus, the district court dismissed your claims for lien and quantum merit with prejudice. You appealed that to the Sixth Circuit Court.
We did.
I don't see where the federal court dismissed the contract claim.
Well, what the federal court did was it limited us to one cause of action. We cannot present another cause of action other than what the Court of Appeals, or the district court allowed. That's our view of it. The only thing that I have that I can assert is the cause of action that we were allowed to go forward with by the Court of Appeals. And by that I mean the Sixth Circuit Court of Appeals, because they did not change that. They didn't change the fact that everything was dismissed but for unjust enrichment. So I don't believe we have, as a matter of law, the ability to go forward as a contract. Clearly, if we've got this dismissal where everything is dismissed but for one cause of action, that's res judicata as to everything except that one cause of action. And that was what we presented to the Sumner County Court. Unless anyone has any questions, that's really, I think, what.
Hearing none. Thank you, Mr. Olson. Will you have time for rebuttal? 5 minutes. We'll now hear from the appellee. Good afternoon.
My name is Jay Wallace Irvin with the law firm of Lewis Thompson here in Nashville, and I'm representing all of the defendants. Before I begin, and it may be in my time, I wanted to acknowledge the fact that when I first started practicing, my first case was in front of Judge Armstrong. It was Chancellor Armstrong back then, and it's a privilege to be in front of you today on the first case that I've had to have oral argument on to be a part of this panel. So thank you. That's
been a while.
just a minute. I've been very fortunate over the past 15 years. I'm going to work backwards, Your Honors, today. First, in terms of the majority of the arguments you just heard, it was focused on res judicata and essentially claim preclusion. That is not something that was addressed at the trial level, and as we noted in our brief, we believe that's waived. Notwithstanding that, we wholeheartedly disagree with the position that Kalos has taken in this appeal, as well as the entirety of this litigation and the litigation that preceded it. I feel it is necessary, based on the arguments today, to give you a recap of both the procedural and factual history of this case. I will tell you that because of the scope, I'm going to be talking a little bit longer than I expected to, so I have a tendency to talk fast. Feel free to throw something at me or yell at me if I need to slow down. There are 3 defendants that are part of this litigation. One is White House Village, Horizon Construction, and Kentucky Property Management. This case arose out of the construction of an apartment complex in White House. White House is the owner of the property. White House contracted with Horizon Construction to serve as the general contractor. Kentucky Property Management actually had no real involvement in the construction. They were going to be the management entity for the apartment complex. So the project proceeds. As it's relevant to this case, Kalos filed a complaint wherein they alleged they provided labor and materials in furtherance of that project and were not paid. That's the substance of the facts. In the original complaint that was filed, that was a complaint that asserted 4 causes of action. The first was the enforcement of a lien. The second was related to a lien discharge bond, because before the complaint was filed, White House Village had recorded a lien discharge bond in the Register of Deeds office for Sumner County, which served to discharge the lien. So at that point, the bond was substituted in place of the lien. The lien no longer existed. The third cause of action was for quantum merit, and the fourth cause of action was a claim for lien superiority, essentially saying that even though the lender, I think the lender was a party at that time, but that the lien somehow had priority over the lender's deed of trust. That action was removed to federal court here in the Middle District. There was a motion to dismiss that was immediately filed on 3 of those causes of action. The lien claim, count 1, quantum merit, which is the same issue we're dealing with today, and the fourth cause of action, which was lien priority. As to the lien claims, the first and the fourth, the basis for the dismissal request was the fact that once you have a bond, lien discharge bond that is recorded, the lien is discharged and of no effect. So it's impossible to enforce a lien that no longer exists. The district court dismissed both of those causes of action on that basis. In terms of the quantum merit claim, it was the same arguments that we see here today. Whether or not the complaint alleges the conferring of a benefit, whether that benefit is appreciated and appreciated under circumstances where retention of the benefit would be unjust, those, for the purpose of today, you can pretend they're admitted, but the problem with both of all of those facts is that it disregards the fact that the complaint alleged the existence of an enforceable contract with Horizon Construction, and setting apart from that, that the complaint did not allege a cause of action for breach of contract. It was not one of the four, as noted in both of the opinions, memorandum opinions that were issued by the district court. Kalos did not assert a breach of contract action for whatever reason. On appeal before the Sixth Circuit Court of Appeals, the Sixth Circuit also noted that Kalos did not have a breach of contract action as part of their complaint for whatever reason. They said, we don't really understand why it's been presented this way, but the only issue on appeal was whether or not the complaint set forth an enforceable cause of action as to quantum merit. It did not challenge either of the rulings on the lien claims or the subsequent dismissal of the bond claim, which is also not at issue.
If I understand it correctly, the federal district court did not rule on any breach of contract claim, but it did, by its ruling on the unjust enrichment, it implicitly said there's a contract out there between these parties. For some reason, the breach of that contract is not before us.
That's a fair summary.
Okay.
So while the Sixth Circuit Court of Appeals action was pending, Kalos filed the instant complaint, which was almost verbatim a carbon copy of the initial complaint. The defendants in this case were also defendants in the prior action, and backing up a step. This is sort of the no good deed goes unpunished, recognizing that there are circumstances under which a quantum merit claim could be asserted. When we requested dismissal, we requested the dismissal be with prejudice as to the lien claims and the bond claims, but said, there could be circumstances where a quantum merit claim could exist. So trying not to take advantage of the situation, requested that dismissal be without prejudice as to the quantum merit claim. Again, that went up on appeal. It was affirmed. While before that decision was issued by the Sixth Circuit, Kalos filed a second complaint in Sumner County for various reasons. The three remaining defendants that are a party to this action, decided to go ahead and file a motion to dismiss in that claim that was essentially just a carbon copy of what they had filed before the district court.
And didn't raise res judicata in that federal?
No, we did not in federal court, and to that point, that is not an issue that was ever raised to the trial court in the underlying complaint here, because it was one where at that point they had already spent several years and a lot of resources on attorney's fees plus time, and said, we just want to be done with this. Let's go move forward. This should be relatively straightforward. It's the same complaint. It alleges in paragraph 3 the existence of an enforceable contract, yet still very clearly only asserts a quantum merit claim for whatever reason in paragraph 10. That kind of is what it is. The judge ultimately, after multiple hearings, and I will tell you this is the 7th occasion that a court has had to hear arguments on the motion to dismiss. In Sumner County, in the second action, that motion was heard and granted 3 times. The first 2 times it was heard, set aside at the request of Kalos to give it an opportunity to appear and argue. In response to the 3rd hearing, when they actually filed a response, the response did not allege, for whatever reason, actually took the position that there was no enforceable contract, despite the fact that paragraph 3, again, of the complaint clearly says there was an enforceable contract. At no time within the response...
In the present action, it says?
Yes.
Okay.
Yes, sir.
All right. But never in the initial action, the one that was removed, was there a claim for breach of contract?
There has never been a breach of contract in either action.
Is there... I'm a little mystified. is there, I mean, is there something about the Horizon contract that has some sort of onerous provision that loser pays I mean, why would you not assert a breach of contract claim?
Candidly, Your Honor, we have asked that question. I've raised that several times to Chancellor Oliver. I will tell you there is nothing in the record. The contract itself is not in the record. The only thing that is in the record are statements that are included in briefing to the Sixth Circuit Court of Appeals, and I believe in this court as well, that said Kalos or its counsel, for whatever reason, made a strategic determination that they did not believe that the defendants would acknowledge, I believe is the way it was phrased, would not acknowledge a contract, and so they just chose not to include a breach of contract action. But at no time, either in the first action or in this action, has there been a breach of contract action pled. And in fact, it has been specifically stated that they intentionally chose not to. So going back to the instant case, the only thing that is before this court is the question of whether or not the complaint states a cause of action against these defendants for unjust enrichment. And for, I'm going to bridge a little bit, bridging to the individual defendants as to Horizon Construction, there cannot be an implied contract cause of action against Horizon because there is an allegation in the complaint that alleges the existence of an enforceable contract. At no point, and as was pointed out by the district court and the Court of Appeal, Sixth Circuit Court of Appeals, at no point does Kalos allege that the contract is unenforceable. And so if there's an enforceable contract, it's a tenet of contract law that you can't have an implied contract when there is an enforceable contract. As to the other two defendants, Kentucky Project Management and White House Village, there is simply a lack of exhaustion of remedies. In this case, it's impossible for Kalos to say it exhausted its remedies because it never even brought the breach of contract claim to begin with. And it has never at any time, whether in the district court, in the initial litigation, or in the Sumner County Chancery Court, explained why or how it either did not bring a breach of contract action or how either of the exhaustion of remedies or the presence of an enforceable agreement can somehow be ignored by that court or this court to somehow resurrect a quantum merit claim where for the past 50 years, based on Pascal v. Dozier, the Tennessee courts have been very clear that you can't do that. And those are the two limiting. So regardless of whether the complaint alleges the conferring of a benefit that was received under circumstances that it would be unjust to retain that benefit without payment, ignoring the facts because they're not before this court, they still haven't addressed the two limiting aspects of a quantum merit claim, again, namely the fact that in this case there is an enforceable contract that has been alleged and that they have not exhausted their remedies to enforce that contract against Horizon. So for those purposes, we would say, again, we would request that this court affirm the prior dismissal of that complaint in terms of respecting Your Honor's opening statements. In terms of our request for attorney's fees and a finding that this appeal will be frivolous, we'll rely on the arguments that we made in our brief. Thank you.
Thank you. Thank you, Mr. Irvin. Mr. Olson?
Yes. The problem we have is we provided benefits to a number of people, and those benefits were not totally encompassed by contract. This was a revolving, moving kind of thing where my clients did work on various buildings. And I don't expect anyone here to know much about what went on up there, but there were buildings here, there were buildings here, there were buildings here. My clients were painting contractors, and basically they were like, hey, now move on to this one, now move on to this one.
But part of unjust enrichment is there has to be proof that the benefit is unjust, and you never know that unless you exhaust contract remedies first. So, yeah, you could say some of the services rendered weren't covered by contract, but we would never know that until you pursued the contract claim and exhausted all claims available under that. So there would never be a chance for us to make that, or a trial court to make that judgment.
They made various payments under the contract, but then as we moved on to other things, they were not paid. And that's where it all comes in. It was, and this is from my clients, they had They had a contract to do some specific work, and then it kept moving. It kept moving. Okay, we want you to do this one too. We want you to do this alcove between the, so they kept doing that, and then they wouldn't get paid. So they basically stopped going back. And respectfully, I want to go back to the res judicata. We're only here on one cause of action. We did not assert a cause of action under the contract. We said that there had been a contract, but we are not asserting that. If it was covered by the contract, we would be suing under the contract. But that's not what we did, because I don't think we had a valid contract for the additional work which was performed. And that's, I guess maybe that's where it breaks down. But the bottom line is they performed work, they weren't paid, they didn't have a contract. And the question in my mind is, do we have something that in some fashion allows us to go forward? I think we stated a cause of action. Respectfully, I do believe, and res judicata and collateral estoppel apply with regards to the Sixth Circuit. That specific issue, I think, is the thing that causes us difficulty with going forward with anything other than the unjust enrichment.
I'm sorry, explain to me how, after reading the Sixth Circuit opinion, they affirmed a dismissal as to the unjust enrichment, and you bring the same claim in state court. That's res judicata. And how does that help you? Although they didn't assert it, so it's waived. But how does that help you?
They didn't dismiss it with prejudice. That is the only, unjust enrichment is the only cause of action that survived. It was dismissed without prejudice. And I'm not trying to take up with counsel. We didn't file that until after, we didn't file this new action until after the Sixth Circuit decision was done, to my memory. We filed it after the Sixth Circuit decision had been filed and basically waited a while to do that. So the only cause of action that survived the Sixth Circuit in looking at the decision, which is of record, is the unjust enrichment. Nothing else survived, period. In fact,
the trial court did not rule on a breach of contract action. The district court did not.
no, but we're also
So how could that court be precluding you from pursuing that action?
collateral estoppel. Everything in our lawsuit, in my opinion, and this is what we advanced, everything in our lawsuit, but for that one item, unjust enrichment, was dismissed.
But how can a court dismiss a claim that was never asserted?
Not saying they can or cannot. It was referenced.
Well, I'm saying it didn't.
Yeah, I'm
saying the U.S. District Court did not dismiss a breach of contract claim asserted by your client because your client did not assert a breach of contract claim.
That's exactly right,
Okay.
because the contracts had been performed. We were on the unjust enrichment.
Okay.
We had unjust enrichment, and respectfully, that's the problem that I have here is.
But if I may misunderstand you, but I heard you say several times the federal court has prevented us from pursuing our breach of contract claim.
In my opinion, collateral estoppel, and I don't think we had one, we didn't try to, but collateral estoppel and res judicata, if the court had just said this case is dismissed with prejudice, I don't have the ability to go back and file something else. I just don't. It was up to us to find a cause of action that survived, and the only cause of action that survived was unjust enrichment.
All right. Thank you, Mr. Olson. Your time is up. And
Thank you very much.
Thank you, Mr. Irvin, for your arguments. We'll take your case under advisement. Call the next case, please.